Appeals Division 1 is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in case number 1CACV21-0367, Roberts versus State. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal, if desired. Also, we have read the briefs and have discussed this case in conference. And counsel, as you know, you may remain at your tables. You have a podium and you have your microphones there. Hopefully you can see your clocks from where you are so that you know how much time you have left. With that, counsel, you may proceed.
Thank you. My name is Michael Napier. I represent the plaintiffs in this case. That would be Mr. Roberts and Miss Christopher Hall. Two cases are involved here. Obviously, there's the case that was abated, and then there's a case that was the reason for the case being abated. One was filed before the other. I'm going to refer to these cases as Roberts 1 and Roberts 2. Roberts 1 was predicated on ARS 23-392, which is a very straightforward statute. I mean, it says if you are a public safety officer that you should get paid overtime for anything over 40 hours. It looked pretty plain to me. I don't think anybody ever previously exercised that statute. Corrections officers are included very specifically in the statute. So we filed Roberts 1 in Superior Court, and we are greeted with a Rule 12 motion to dismiss, where, of course, the allegations that are in the complaint are taken as true. The court in Roberts 1, I'm going to track these cases for you so you can see how they interplay, and I think it'll have some influence on what the ultimate decision is. But the court in Roberts 1 made a determination that because of administrative regulations that the Portal Act, part of an amendment to the Fair Labor Standards Act, had been incorporated by administrative rule into the overtime statute, 23-392. Well, that was a surprise. I asked to amend, and naturally in a Rule 12 motion, I mean, if it doesn't meet the criteria for stating a claim under the Portal Act, we can fix that. I was denied an opportunity to amend.
Counsel, didn't you amend once?
Yeah, previously, before the ruling, yes.
Right.
And
so this would have been your second amendment that was denied.
And you'll see in a moment what plays a part, that amendment plays a part in the ultimate outcome of the journey of Roberts 1, in the sense that I included two paragraphs that arguably could qualify for stating a claim under the Portal Act. I was not going to concede to the Portal Act. I mean, I thought we could have the Pendergast test, and when I say that, I'm referring to the Tempe case where Code 7, your time is restricted by your employer. It's for the benefit of your employer, Code 7 lunchtime. It's for the benefit of the employer. That's the test under Pendergast. It's very simple. It's not that stringent. So I didn't want to capitulate to the more stringent test under the Portal Act, which was, of course, you have to show that your time spent was not just for the benefit of the employer or you're restricted in any sense. You had to show that it was integral and indispensable to the very purpose for which you were hired. And that is a much more intense analysis. And so I walked kind of a line there.
So you made a tactical decision not to include that until after, or the briefing of the motion to dismiss?
Exactly. Yeah.
Okay.
Your Honor, I was told that I didn't want to include it until I was told I had to, but I walked, kind of straddled the fence a little on 16 and 17, which, as you'll see, the Court of Appeals took note of on Roberts 1. So, Pendergast apparently is out, Portal Act's in, we got dismissed, we didn't get a chance to fix the complaint, so naturally I appealed. Why wouldn't the plaintiffs appeal? I mean, we had to preserve the claim for security screening, for time spent, time worked, and get paid overtime. And in addition to that, the clock's running, and the sooner you file, the further back you can go. So I didn't want to lose that filing date for Roberts 1 in terms of damages. Although the practice didn't change until I think recently, and I can't be quite sure of that. In any event, we appealed. Roberts 1 goes to the Court of Appeals. So actually, I've been at the Superior Court twice, Court of Appeals now twice, and the Supreme Court. Here we are, second time at the Court of Appeals on these cases, and this one, of course, is Roberts 2. In Roberts 1, the Court of Appeals said when you did state a claim for the Portal Act, and by the way, this work this security screening time is indispensable and integral to the job of preventing contraband coming into the prison or securing and controlling the prison population, and found in favor of the plaintiffs in all respects, and remanded it back, obviously, only for the certification of the class and damages. Well, I expected that would be there'd be a petition for review, and I wasn't surprised. The council did what I expected, and the Supreme Court took the case on a petition for review. Roberts 1 is now pending in the Supreme Court. The Supreme Court, I'll say, showed a keen interest. It was as though we were past whether Portal Act was in or out. I was hoping, of course, that they would affirm, they will affirm the Court of Appeals. That would be nice. By the conversation in the Supreme Court, I don't expect that. But they did show a keen interest in whether the Portal Act actually is part of 23-392.
And that case was argued in December, right? Supplemental briefings in, and it's pending before that court.
Exactly, Your Honor.
In this case, we're here on Roberts 2, of course. It was filed 5 days after you filed your notice of appeal in Roberts 1, right?
I think that's about
give or
right.
take, yeah. And then, so it has a lot of similarities, so many similarities that the Superior Court found abatement applied to this case.
Yes, and we think the Superior Court erred in that respect.
I read your brief that same way, and I would be happy to hear more about your position on that point.
Yes, on the abatement. First of all, the abatement question is going to be influenced by what the Supreme Court does. It's kind of like a moving target as we speak today. But in any event, yes, in Roberts 2, the court looked at our complaint. And keep in mind, our complaint was, we fixed the deficiencies in Roberts 2 that the court observed in Roberts 1, the basis for the dismissal. Now, there's no Portal Act here. I'm going to dismiss it because the Portal Act is part of 23-392. So we fixed the complaint. Remember, we weren't allowed to amend. It was without prejudice ruling, however, so we could refile, and I explained why we refiled. So then Roberts 2, the judge in Roberts 2 made the decision on abatement before the Court of Appeals ruled on the fact that the Portal Act was actually in that Roberts 1 complaint. In any event, the court in Roberts 2 said this case is abated because of Roberts 1. Well, I got to ask you, theoretically, hypothetically, how do we fix the complaint that's deficient with regard to the allegations incorporating the Portal Act if the case is abated by a case that didn't have the Portal Act? The effect is with prejudice ruling.
But didn't the Court of Appeals in Robert 1 say the dismissal should have been with prejudice?
Oh, no.
The
No.
Court of Appeals in Roberts 1 didn't say the dismissal should have been with prejudice?
Oh, no.
I thought they had a footnote saying
They
that.
didn't get to the amendment question, whether we should have been allowed to amend.
No, but from an appellate jurisdiction question, typically a dismissal without prejudice is not an appealable order.
Oh, I don't think they actually addressed that. I could be mistaken, but, and maybe refer to counsel, but
I thought they at least discussed that.
what they did is they said there is a plural act here, and we're going to find that not only is it pled, but indeed, these officers, this counts as time worked under the plural act, and they remanded it. They didn't get to the question of whether or not we should be allowed to amend, which gets to the,
The point was a little different. It was the nature of the dismissal. I thought they discussed whether the dismissal in Roberts 1 should have been with or without prejudice. I thought they addressed that.
do you recall that?
I think they might have said that it was in effect.
Yeah, well, because of because they didn't allow us to amend. Juliana recalls that maybe it was in effect, they observed that it was in effect a ruling of, with prejudice. But I mean, how do we go forward if we don't? Well, we had to appeal it, but we also had to fix the complaint so that we satisfied the requirements, the basis for the dismissal under Rule 12 by the Roberts 1 court.
Could you talk about the new legal theories and facts that make this Roberts 2 different from Roberts 1?
Well, as we know, abatement, in the Allen test, they call it in Arizona, abatement looks at the parties, are they the same? Is the subject matter the same? Are the issues the same? And is the relief the same? Here, we believe that the only sameness, so to speak, is with the parties and the relief. We think that the subject matter and the issues are different. And why I say that is because one complaint may be, depending on what the Supreme Court says, may be just confined to a non-portal act allegations. The second complaint is strictly portal act in spades. I mean, we've laid it out. And so when I say the subject matter is different, sure, we're seeking overtime, but if you have the portal act analysis versus Pendergast, which is non-portal act, they're not even the same analysis. They're different claims, and they have to be in order to satisfy the requirements. And you have to, and the evidence has to be much more detailed, more intricate, in order to satisfy the test under the portal act. That's a different claim altogether. It has to be a different claim. I mean, why did we get tossed out if it's not a different claim? That's why we got tossed out on the Rule 12 motion in the Superior Court.
So, counsel, your position is, let's use a hypothetical. You could have proceeded through jury trial on 23-392 claim and either won or lost, and then the next day filed a portal act claim and everything would have been fine. There would have been no merger, no bar. The first case wouldn't have had anything to do with the filing your portal act claim. Is that your position?
Well, no, because we wouldn't, if we go through 23-392 all the way through a jury trial, we weren't tossed out on a Rule 12 motion.
Right.
No, there'd be no reason to file Roberts 2.
But would you be entitled to file something to allege the post-shift time if you'd gone all the way through trial, had been successful or unsuccessful? Can you now go in and say, well, we want to be compensated for post-shift screening?
Well, there was a form of that, yes, in searching of cars after shift, but no, because, well, yeah, if it was security screening. Here's another difference between the complaints. One was confined, the first one was confined to security screening. The second one brought in all of the activities that the guards engage in that would qualify for compensation.
But that's what I'm asking, though. Let's say you'd gone to trial and you'd been successful on your first complaint.
Right.
Can you then file a new complaint saying there's other aspects, other screenings we want to be paid?
Yes, we could have, to answer your question, but more likely we would have amended and brought in those other activities as time worked under Pendergast, and ultimately go to a jury unless we get motion for summary judgment based upon, affidavits and such, and then we're done.
But your decision not to do that here, it sounds like was strategic. I mean, you did amend once as a matter of right, and you could have brought those things in, fair?
Yeah, it was strategic. The cases that were out there, I mean, this is an emerging area of law. The cases that were out there were security screening cases. And then, after we filed, these cases were evolving, and other cases surfaced. And those cases addressed other activities as time works, such as debriefing, exchanging radios, getting keys, being on alert and looking out for melees while you're traveling in the interior.
But you're saying that was the reason for not initially including that, was just that case law hadn't developed somewhere else? They seem like very similar claims, and seems like could have easily been included in the first complaint.
Yeah, could have. I agree. But, I'm reading case law, and I'm seeing security screening. Now, whatever happens in the Supreme Court, if they find the Portal Act is involved and is part of the claim, then we have no abatement because it's a different cause of action than Roberts 1, I say. If they find that the Portal Act is not part of Roberts 1, then we go back down and we can amend. There's also the possibility that Roberts 2 gets remanded and we can consolidate. There's different ways to do it, I think. The dismissal without prejudice and not allowing us to amend took us on these paths. It's not like it was by choice. And, we brought in, I must say, Your Honor, we brought in those additional claims, I thought, based upon the developing law. And the cases that we were looking at were a Missouri case and the New Mexico case, the Aguilar case.
Counsel, why didn't you, if it was a dismissal without prejudice, and that's what the Superior Court said, regardless of what the Court of Appeals said in Roberts 1, why didn't you the next week file a new case, bringing everything in one bucket?
I didn't want to lose my damages. Roberts 1 went way back. I mean, from the date we filed it. So I didn't want to, and we did file a new action, obviously, with the Portal Act involved, which I say are different issues and different subject matter, not just security screening, other subject matter. I don't think this is abatement. But anyway, that's why.
But you're saying this one's so different, completely different than Roberts 1, and my question is, why didn't you fix the issues with Roberts 1 in the superset that you're talking about now?
Well, before you file against the state,
right,
you have to file a notice of claim.
Correct.
We had not filed a notice of claim with regard to the other activities.
So you were precluded in Roberts 1.
We had to file a notice of claim first.
Right.
Wait 60 days. That's why. That's another reason. And I didn't want to lose the start time on the claim for the class action. I'm going to save some time, if that's okay.
All right. Thank you.
Thank you.
Excuse me. May it please the court. My name is Kirsten Story, and I am appearing on behalf of the state of Arizona. So I'm going to focus my remarks on the Superior Court's proper recognition that the plaintiff's first lawsuit, Roberts 1, abates their second lawsuit concerning basically the same dispute. But time permitting, I'd also like to address the plaintiff's request for fees in this case as well. But I'll begin with abatement. So what plaintiffs are really asking for in this appeal, and I think that this panel is kind of really circling around to it, is that they want to pursue their overtime claim in two lawsuits in two courts at the same time. So we have Roberts 1, right, that has already come up through this court and is pending in the Supreme Court. And then we also have this case, which we are appearing before today. And the problems with this two lawsuit situation are relatively self-evident, right? It's contrary to judicial economy, right? So I think Judge Thumma kind of hit that a little bit. Why not just in one super action or pursue your claims in the appeal, right? It also risks mutually inconsistent rulings because we have two litigations going on in parallel. And more readily, this situation is exactly what the law of abatement seeks to avoid, right? So I think that our best, example of the law of abatement really comes in the Reese case, which you cited in our briefing that you've read, right? And the test for abatement under that case is whether the two actions present a substantial identity as to the parties, subject matter, issues involved, and relief demanded. So I want to focus on that substantial identity because the Roberts plaintiffs want to call it the same, but the test is not whether or not the cases are the exact same. It's substantial identity. And that's why in the Reese case, for example, you have a probate action that will abate a common law conversion and unjust enrichment lawsuit, right? The legal theories can be different. And by extension, the facts and the facts pled may look different.
But doesn't this involve additional time, additional damages? It's a little bit different than the probate where they're just seeking the same presumably damages. Here, aren't they suggesting there's additional activity that's also covered, should also be compensated? Does that change it at all?
If it was actually additional activity or additional relief or additional subject matter, that would be the case. But if you look carefully at what these additional facts are they're claiming are pled, it's just more factual detail and specificity as to the overtime, the same amount of time that was addressed in Roberts 1. So if you
the
look
exact same amount of time, I thought Roberts 1 was the pre-screening, and then the second one includes additional screenings.
So Roberts 1 is broadly framed in terms of two categories of time spent, right? It's going to be the security screen and the time traveling from security screen to workstation. And the contention in both claims is that the time that the security screen constitutes either the beginning or the end of the work day, right? And it's important to focus in on those bookends because, as kind of pointed out in the briefing and also recognized in the current complaint, we're under the continuous workday rule, right? And so the time spent after the security screen or before the final security screen at the end of the day is going to be the continuous workday that they're looking for compensation on.
Counsel, do you agree then that the notice of claim served in advance of Roberts 1 counted for both pre-work screening and post-workday screening? Is that your position?
I would have to look carefully at the notice of claim in Roberts 1. I think that for the purpose of abatement, because we have multiple notices of claim in addition, as counsel's referenced.
Right.
So there are multiple notices of claim that have been filed, and as counsel pointed out, he would have amended the complaint to include the additional time. And I think that's where the abatement issue comes into play here, right?
Well, and I just want to make sure I understand your position, because if your claim is that Roberts 1 dealt with both pre- and post-screening time, and Roberts 2 does as well, that suggests to me that you're not pushing back on the notice of claim governing post-shift activities in Roberts 1, and I want to understand your position better on that.
I think that issue was not before the court in Roberts 1, and when Roberts 1 was decided, I don't think we had the secondary and I think third notice of claim filed, and so that was sort of an issue we never addressed, and so I'm not sure I can take a position on that in particular in the context of Roberts 1. But certainly by the time we got to the time that this complaint was filed, and this case was also up on appeal, including whether or not the amendment should have been permitted, that was a potentially live issue, right?
Doesn't that cloud then abatement? Because abatement does a compare and contrast. between Roberts 1 and Roberts 2 as applied here? And if it's uncertain, the scope of Roberts 1, wouldn't that undercut the validity of abatement?
I think that the scope of, the question of the scope of Roberts 1 is, it cannot be divorced from the fact that the plaintiffs also requested leave to amend. And that amendment is also at issue. It came up at issue in this court, and it also is currently pending before the Supreme Court. So the reality is that time spent, the security screen and the time spent going between security screen to primary workstation is at issue. It's at issue in both cases. It's the subject matter of both cases. The compensability of that time is the issue addressed. And so the relief is going to be the same.
I understand that. The focus, though, of our questions is the post-shift work, which seems to be very much at issue in Roberts 2, less so, if at all, in Roberts 1.
I think that it was not, it's really kind of not the primary focus of discussion, because what the courts in Roberts 1 are focused on is the security screen. But even the post-shift work that's being referenced in this case is really tantamount to a security screen as well, right? Because what they're talking about is driving up to another security screen before leaving. So if you look at the allegations in the complaint, that's once again, and that's a check that's for security purposes to make sure that there's not inmate escape.
Let me ask a hypothetical then. Let's say, without conceding, that case 1 deals with pre-shift screening, which is absolutely security coming in, right? And that is resolved one way or the other. And then the second case solely focuses on post-shift issues, whatever they may be, turning in radio, keys, fill in the blank. Would your argument on abatement be the same? Do those two issues, one focusing solely on pre-shift activities, the other focusing solely on post-shift activities, would those satisfy the Allen test for abatement?
I think assuming that if we are in that hypothetical situation where Roberts 1 solely involves pre-shift and Roberts 2 solely involves post-shift.
And I even took it away from Roberts. How about that?
Right.
So we don't...
Yes. So if we had a case where pre-shift, pre-shift activities are at issue, and a second case where post-shift activities are squarely at issue, and that's it, and there's no question in terms of whether or not the allegations can be read to encompass pre- and post-shift activities, then that might be a different situation, because you might be looking at different subject matter and potentially different relief, right? But in this case, the pleadings don't kind of differentiate that clearly. So both cases...
But didn't counsel suggest that the notice of claim only included the pre-shift screening, and if it didn't include post-shift screening, I guess back to the same question I asked counsel, if they had been successful in the Superior Court on just their original complaint, would there be any basis for not allowing them to file a second complaint alleging post-shift screening an entitlement to compensation?
A second lawsuit.
A second lawsuit. They prevail on the pre-shift screening argument, but they hadn't included other types of screenings. Any reason why they can't file a second lawsuit saying they have to file their notice of claim, we're entitled to post-shift screening compensation?
I think that there might be potential claim and issue preclusion issues, because I believe that the tests under those doctrines are all claims that could have been subsumed within the first complaint. I apologize, I haven't really kind of looked at claim and issue preclusion, because that's not necessarily at issue in this case, because we don't have finality.
Counsel, let me ask you, what if instead of what happened here in Roberts 2, there was a request to stay Roberts 2 and consolidate it following remand of Roberts 1, wouldn't that have resolved the issues that we're asked to address here?
I don't agree because we still have a situation where we have two lawsuits proceeding in parallel.
Let me ask you a better hypothetical then. Not only stay, but also consolidate the cases and then await the decision in Roberts 1. Wouldn't that resolve the issues that abatement is designed to protect against?
I don't know necessarily if that would resolve it, because again, we're in a situation where you have two cases, yes, proceeding on the same thing. I don't know that there would be any practical benefit to consolidating them, because really plaintiffs can obtain all of their relief in Roberts 1. I think it's very telling, the plaintiffs have been clear that, this case can turn on what happens in Roberts 1, right?
What's the objection then to consolidating? If you're saying it's the same relief and they're suggesting there's just some other damages they're interested in pursuing.
I don't know that we necessarily have a strong substantive objection. It just, to me, it doesn't do anything practical to hold that case open when really you're just going to be folding it into the same lawsuit. Nothing will happen, right? And so I think that the reason that we have abatement is that you're not pursuing, two different lawsuits at the same time.
Agreed. But you said in that world that nothing would happen, so there would be no prejudice. You wouldn't be incurring attorney's fees. You wouldn't be conducting discovery, disclosure, other things that abatement is designed to protect against when you have parallel path litigation. If instead you combine those two, doesn't abatement simply go away?
It would, but the reality is, I think that, if we're looking at whether the court erred in dismissing the case, as opposed to maybe staying it, I don't know necessarily that that's a situation of error, right? Because if there's no difference between the plaintiff coming back down and pursuing their relief in Roberts 1, and then having it folded in, then there's no reason to hold that case open, that second case open. But if, on the other hand, Roberts 1 goes in favor of the state, which we also hope will happen, then we have this open case that's been pending the entire time that really should not proceed, right? Let
me ask then, looking at it from the opposite end of the telescope, if the dismissal of Roberts 2 is affirmed, are you indicating that the state would not argue that's preclusive for anything in Roberts 1?
No, because I don't think that we would argue that, because we don't have any sort of ruling on merits relative to Roberts 1.
But so a decision that you couldn't press the claims in Robert 2 wouldn't be used to claim that the claims in Robert 1 should fail as well?
The court's dismissal on abatement grounds in Roberts 1, we would not say that prevents the substantive claims in Roberts 2, because the abatement is simply just because it's duplicative litigation.
And let me make sure I heard you right. Did you say you wouldn't argue Roberts 2 dismissal would preclude in Roberts 1? That was really my question.
No.
I think you said it the opposite.
No, it's not a merits decision. So no, we're definitely not trying to play sleight of hand here. The reality is that what we're here, the motion to dismiss and the court's appropriate dismissal in Roberts 2, this case, is really a matter of avoiding the situation that we have here, where you've got two litigations proceeding in parallel. And it's unnecessary, it's contrary to judicial economy. And so the court made a proper ruling that we don't need this second case proceeding in tandem, and the law of abatement, really does permit that situation. The case is pending in the Supreme Court, and the plaintiffs can pursue their relief, including their request to amend the complaint. I know that they have a lot to say about what do we do, what relief do we have when, the court denied our request to amend the complaint below. They had a choice. They could appeal it, or, they could, go with the court's without prejudice ruling. Now, yes, in Roberts 1, the court did say in Note 1 that it should have been with prejudice. That's true. But they also had relief in the form of pursuing their appeal and arguing on appeal that they should have been permitted to amend their complaint, which they did. So the amendment is pending before another court, and that's why this abates.
Is the application of the doctrine of abatement, which is represented by really a handful of cases in the history of Arizona law, it's short of issue or claim preclusion, as you point out, it doesn't require a judgment. Is the application of that doctrine discretionary, or is it a matter of right?
I believe that it's discretionary. I know that Alan references it as a jurisdictional issue, but I think that jurisdictional language has been modified in subsequent rulings. So it's a doctrine of judicial economy, but it serves strong purposes, including, sort of what I've referenced before. And I think that those purposes are demonstrated squarely in this case. When you have two lawsuits involving the same overtime claims, addressing the same issues, and the only difference between the two, really, if you look at it, is what legal theory did the plaintiffs decide tactically to pursue in each case. And the legal theory and the tactical choices don't govern whether abatement applies. It's whether it's subject matter, relief, parties.
But if the relief is different, if they can't go back as far recovering damages, doesn't that counsel against abatement? Isn't that a different
If that was
relief
truly
proceeding?
the case, however, if they were able to amend their complaint, which is at issue in Roberts 1, then that would give them that relief.
And counsel, our review is de novo, correct? We
Correct.
review this, and we review the same documents that the Superior Court was asked to.
Correct. That is correct. That is the standard of review. So I see that I have a couple minutes left, and I do want to touch briefly on the request for attorney's fees under our cap 21. I think our cap 21 is pretty plain, that you have to specifically state the statute on which your attorney's fees claim is based. The fee request here is far from specific. There's a whole broad range of statutes that are referenced, and none of them are pinpointed. This is exactly the opposite of specifically stating the statute. I know plaintiffs have, in their reply, relied on Moreno versus Silva, but all that case holds is basically you don't have to have a Westlaw site for your statute, as long as you have some language that specifies the particular statutory basis, right? And we don't even have anything in their fee request pinpointing any statutory basis. And so their fee request does not satisfy our cap 21. But in any event, no fees should be awarded in this case, given that the Superior Court properly determined the plaintiff's first lawsuit abates their second repetitive lawsuit. So really, if anyone should bear the cost of filing repetitive litigation, it should be plaintiffs. So if the court has any further questions, I'm happy to entertain them at this time. Otherwise, we rest on brief.
Thank you, counsel.
Thank you.
Thank you. Just a few responses or comments. I want to be sure that this court understands the spectrum of the claim in this case. The expansion of the claims. It's not simply pre-screening and post. It's everything in between as well. And under the FLSA, the first activity that constitutes time worked, integral and indispensable for the purpose of the job for which you're employed, and everything after that becomes compensable and considered time worked and compensable as overtime. So it's much more than just screening at the early in the day and screening at the end of the day. It's everything in between. It's the exchange of equipment, the keys, the radio, the debriefings, being on alert within the compound. All those things were included in Roberts 2. Because we expanded the basis for the claim, we stated, in effect, new claims. We stated a new theory.
But are you saying they were not being paid for activities that occurred during their shift?
They were being paid for their 8 hours, but they spent more time than that if you include these other activities. And we say those other activities looking at the Hootsell case from Missouri, Supreme Court case, and the federal case, Aguilar from New Mexico.
Other activities pre and post shift.
Yeah, exactly. So we're saying they're compensable. Their time worked and compensable is overtime. If they
I'm just
take-
not following what you're suggesting is happening in between, why that wouldn't already be compensable if that's part of their 8-hour shift.
Well, because I think they check in at their work site, and they do other things before they get there. It's similar to, claims under the Fair Labor Standards Act for briefing time, or donning and doffing, and things like that, that actually didn't meet the standard. But here, I think that this does. It certainly did in Aguilar and other cases that we cited in our Supreme Court brief and a Court of Appeals brief in Roberts 1. Another thing this goes down quickly, want you to be aware of is that absolutely the notice of claims were different. One was Portal Act, one was not. We did ask for a stay in this court, by the way. A suggestion might be to abide your decision here and see what Supreme Court does. Maybe you want supplemental briefing. That's a possibility.
Counsel, you're out of time.
Amount of time, you're right on it. Okay, thank you.
Thank you for your arguments. This
Okay.
matter is now taken under advisement, and we will issue a written decision in due course. We're going to take a brief recess to set up for the next oral argument.
Thank you.